Further hearing in the Queen on the application of Bashir and others against Secretary of State for the Home Department.
Yes, sister.
My lady, just one point from yesterday. My lady would something ask you about the relevance of the Cyprus Act. And I said the relevance was zero. I think it's putting it too high. The legal relevance is zero. You can't enact a state. But it would certainly be evidentially relevant. It would evidence recognition by perhaps the most significant state in that context. So then can I move, please, to our first argument as to why the Refugee Convention applies. This is our case at paragraphs 34 to 54, pages 186 to 190. Can I just say that what I'm aiming for is 30 minutes on this, very briefly on the second argument about sufficient continuity, about an hour on bon coup, and then a couple of hours on breach, which will take me to 3. Obviously, I'll try to do it before then, but given what my lady said yesterday, that's the broad idea.
Well, I'm only speaking for myself. You mustn't,
of course, my lady,
assume what I say goes for.
Of course. Oh, well. So,
6 other people.
Our first argument, we say the SBAs are not a new political entity in the sense in which Lord Hoffman deployed the term. There is a framework dispute between my learned friend and I. He says you look at everything. We say you look at the law. And I want to make 3 preliminary points to justify my framework. First, we say the question is one of law and not evaluation or impression. Domestic classification of the entity as new or separate is necessary for the constitutional unit to be new. That is not the position here. It was the position in bon coup.
Say that again, just to judge.
Yes. we say the question is one of law rather than impression.
I see that. Well, it's certainly
Well, it's
going to be
both,
one of
isn't it?
impression.
I mean, you have to formulate a legal test and you then apply it to some facts.
Right.
But you don't, I haven't put it well, I'm sorry. What you don't do is look at everything. My little friend says you look at everything, all the circumstances, use, governance, size, borders, energy supply, everything.
Surely you look at everything that tells you what sort of thing the SPAs are.
No, we say with respect that the critical thing to look at is the legislation, because that's what affects the status. Because we say if you look at Article 40, assume that territories does not mean land, then the reference to territories has to be a constitutional unit that is recognised as separate from the metropolitan territory. It has to be something separate from the motherland. And in our law, the unit, the constitutional unit, that is separate from the metropolitan territory is an overseas territory. They are separate constitutional units, as Henry and Dixon say in their work. So, by political entity, we say Lord Hoffman should be understood as meaning an overseas territory, a new overseas territory, recognised as such under UK constitutional law. You don't look behind the constitutional status of the land to other features, such as governance, use, size, name. The question is whether there is a new unit as a matter of domestic law.
Well, isn't it whether the old unit has ceased to exist rather than whether there's a new unit? I mean, we're talking about, there's no doubt that the convention did apply to Cyprus in its old form.
Yes.
The question is whether it still applies to what's left of it.
Yes, so you're
in Bangkok, you have a new entity, but you cease to have an old entity. So, but your case here is that there's enough of the old entity continuing for the obligations attached to it to continue as well.
Absolutely, it becomes very clear, for example, when we'll come to...
I mean, that's the way it's put by Professor Finnis in the part you quote about.
I was just going to mention it as it happened. Absolutely, the contrast is very clear.
This is, you say it's a matter of law, this is a matter of international law.
No.
Why not? We're talking about
No.
whether something exists for the purposes of knowing whether a treaty continues to apply with it.
Our primary submission, which for forensic reasons we are dealing with third here, our primary submission is yes, this is a question of pure international law. You should not be looking at domestic law. Here, assuming Bonku is right, you have to, because international law is not going to tell you whether something is a political entity or not. It doesn't exist. The concept does not exist in international law. So what can you do but look at the domestic law? Because, and with a view to determine it.
I'm surprised that international law doesn't have a view as to whether a treaty continues to apply. It seems to me that in Bonku, what the court was doing was asking itself whether a treaty continued to apply, and in that context, it was looking at an international law concept, namely whether there was still the same entity as had subscribed originally to the treaty.
Yes, that's exactly what it was doing. However, the problem is that there is no such thing as, there's no international actor known as a political entity.
Well, that's what you say, but Bonku is a decision to that extent, perhaps, about international law, and establishes that there is such a concept.
Well, yes, it does.
I mean, we have to work out what international law is sometimes.
Well, assume we're wrong on the third argument. So this, as it were, the House of Lords has developed or discovered or whatever a rule of public international law. So whether or not something is a new political entity or not absolutely sounds in international law. And that is a very important reason why we say you cannot have an impressionistic analysis, because other states are not need to know what is happening.
Yes, and I mean, the point that I was going to go on to put to you is that, I mean, you say that you disregard all these other things which Lord Sumption mentioned, but why necessarily, if they are actually prescribed by or integral to the international law arrangements which have been made? And we go back to the Treaty of Establishment. And
because you have to look at what territory must mean in the clause, Article 40 here. You've got to look at what territory means. If it doesn't mean land, what does it mean? It's got to mean something other than the metropolitan territory. That's the silent premise of the clause. It's got to be something different. Well, what is it that's different in UK law from the metropolitan territory? It is an overseas territory. How do you determine whether an overseas territory is new? You look at its status. You look at the Order in Council or the Act of Parliament, and the legislature here, whether the Queen or Parliament, is very well capable of saying this is separate. There are lots of examples. The Antarctic territory, the Biot itself, my very assiduous juniors have found numerous examples.
well, give us some references.
I'm sorry, it's not in the papers. We didn't want to overburden you, but I can give you some more.
Well, it's not very helpful for me, at any rate, if you actually don't give us the references.
There are two that you have, and that is the Biot itself. We'll look at that in a moment. And also...
Do you actually mean that it's not a question of international law? Surely international law has a concept that there are certain entities that are subjects of international law. Most of them have an international legal personality, but some do not. International law has to define what is a new entity. In the case of an overseas territory of the United Kingdom, it may well be that UK law then has to determine whether the particular entity has the characteristics required by international law. But it's a bit absolutist to say that either one of them is irrelevant.
Sorry, I didn't quite understand the force of my Lord's question. But it's absolutist for me to say that...
You appear to be saying it is simply a question of UK
Yes.
law.
Well-
UK law may, perhaps on its own, perhaps among other factors, determine whether the sovereign base areas have the characteristics which international law expects to see in an entity, and whether the entity is the same as that which international law considered to exist before 1960. So you can't say that either one or the other is irrelevant. They're both relevant for different purposes.
With respect, no. Yesterday you put to Mr. Eady, well, look, you could say the sovereign base areas don't have the characteristics of a state. Well, they're not supposed to, because one of the characteristics of a state under the Montevideo Convention is the capacity to enter into international relations. Well, Cyprus never had that, the colony. SBAs don't have that. But do they have a defined population? Well, just about. Yes, they do. Do they have a government? Yes, they do. Do they have territory? Yes, they do. It looks like an entity, whatever that is. This is slightly odd because a lot of the points that my Lord's putting to me belong perhaps in our third argument.
Well,
Our third argument.
Perhaps you better get on to it and then we'll see.
Yeah, it
That
might
would
be
be
better
helpful.
to reverse the order because I think that this may overtake some of the debate.
I'm happy to do that. So our third argument, I'll take that first. If that, I'm very happy to do that. We've set that out at paragraph 73 to 125, pages 198 to 218. At paragraph 75, we say that principles of international law make it clear that an extension of a treaty, even when done by reference to the name of a colony or other overseas territory for which a state is responsible, represents an extension to the underlying landmass, the territory for which the UK is responsible in international law, and that a change in the colony as a matter of domestic law does not affect the UK's international responsibility for that territory. That is the result that international law drives. Here, the extension to the territory of Cyprus had the effect that so long as the UK remained internationally responsible for the territory of the colony, the land that it comprised, changes to the domestic status of the territory would not affect the application of the treaty. So even if the territory of Cyprus, this is a point my Lord Sumption put to Mr. Eady, meant the colony of Cyprus, the question is, what was the effect of such an extension to the colony? Now, can I please take you very briefly to Bonku, because I think although you looked at Mr. Crowe, Queen's Counsel submissions, you didn't look at Sir Sidney Kentridge's. And Sir Sidney's submissions are at 471D. Sorry, it's volume 1, tab 1, electronic 2952.
Sorry, say it again.
2952. So we're in the argument, and my Lord Wilson took Mr. Eady to Mr. Crowe's argument over the page. This is to Sidney.
Sorry, I don't think it can be 29, 22.
2952.
52.
Sorry, did I say 22? So sorry.
No, I may have misheard.
So we're in the middle of
Letter D.
Sir Sidney, letter D.
Sir Sidney, letter D. If the claim submission is otherwise rejected, his valid claim to relief under European Convention has at all material times applied to the Chagos Islands by virtue of declaration extending rights to the territory made pursuant to Article 56 in the absence of any denunciation. The order creating by it cannot be read as diminishing the inhabitants' rights, and so forth. So that is the argument. And then you've seen across over the page Mr. Crowe, Queen's Counsel's argument. And then Lord Hoffman, you've seen at 64. Can I please just take you to Lord Mance, where my Lord describes what actually happened, namely that the Chagos Islands were joined with 3 other islands that were previously part of the Seychelles, Aldabra.
Don't we know that now?
Sorry, my Lord?
Don't we know that now?
Yes, but the point was that it is set out there in your judgment.
It's 139. You cited in the case as well.
Indeed, my Lord. I think what happened is that, as you say at letter B, at page 2996, the wrinkle in the story is that in 1976, those 3 islands were returned to Seychelles as it prepared for independence. So what you ended up with was territory that used just to belong to Mauritius. But when they were created in 65, you had this joining. And then we have Lord Hoffman at 2970, paragraph 64. And the key reasoning is over the page at 2971. And that reasoning is that a declaration, as appears from the word for whose international relations it is responsible, applies to a political entity and not to the land which is from time to time comprised in its territory, by it has since 1965 been a new political entity to which the convention has never been extended. If we'd gone argument 1, you'll have seen the legislative provision which made it completely clear, and Professor John Finnis's view, as my Lord Carnworth noted earlier. So the key here is that territory means political entity, not the land. It's that clause which transforms, it's the responsibility clause which transforms territories to mean political entities, so that where a state creates a new political entity over the same land, in respect of which an extension has been made, as in Bonku, as here, then a new extension is necessary, and that's the sum of the reasoning. We say that's wrong for the following reasons. Firstly, the reason I touched upon yesterday, which is that a state can be responsible for the international relations of a landmass. And we gave examples in our case at paragraph 78, where they may be uninhabited landmasses, territory, in respect of which a state might have and conduct international relations. For example, assert rights of exploitation, fisheries, incur duties as to search and rescue, salvage, and in respect of which it may extend a treaty.
Well, anybody who was in Quark
Yes.
appreciates that point.
Yes. We were going to hand up a Kiribati treaty. I won't do it, but I can just tell you about it because the point's obvious from Quark. But to get the US in 1979 relinquished sovereignty claims over uninhabited islands to Kiribati in exchange for being consulted about military bases being constructed, about them being used, and about fishery zones. Uninhabited land masses, international relations between Kiribati and the US.
But this seems to me slightly odd. It's not the Earth which is conducting international relations. It's people. There may be no inhabitants, but there are still people responsible for the country, and it's still, therefore, in some measure, a political entity.
With very great respect, I resist that, because the overseas territory is never conducting international relations. It is always the state that's conducting.
People in respect of the overseas territory.
Well, my lord, in the Quark case, there were 12 scientists, a permanent population of nothing but wildlife, as my lady put it, and the ECHR had been extended to that entity.
Yes. Well, no doubt the scientists benefited by it, but it doesn't meet the point I was putting to you, which is that it's not Earth which conducts international relations. It is something more. It is a political entity in respect of that particular territory.
With great respect, my lord, with very great respect, it's confusing the state,
Yes.
which is responsible in international law, which is the primary actor. There can be other situations, entrustment.
But you can't just talk about the state when you're talking about a dependent territory, because you've got to ask, in what capacity is the state acting? Is it acting as the sovereign of, in this case, the SBAs, or the sovereign of the United Kingdom? These are distinct capacities for international law purposes. Just as, for example, the Polish state had two capacities in relation to the state of Danzig, the subject of two International Court of Justice judgments in the 1930s.
But the default rule, my lord, is that the state of the UK acts in respect of its entire territory. We see that from Article 29 of the Vienna Convention. The territory of the UK in international law is something different to the territory of the UK in domestic law. The Interpretation Act 1978 defines the UK differently. In international law, the territory extends to everything.
You're saying that every single British overseas territory, together with the metropolitan country of the United Kingdom, all constitute a single entity for international law purposes.
Absolutely, and there are about...
We may well have to produce justification.
There are about 10 references that we have from very eminent academics at page 201 of our printed case.
Page, is it?
Sorry, did I say paragraph? Page 201. And it's the paragraph begins at 83, but it's over the page, and you'll see a number of respected sources cited for the proposition that Article 29, a codificatory article of the Vienna Convention, which says that a treaty is binding upon a party in respect of its entire territory, that includes overseas territories.
Well, you say it includes overseas territories, but is that what the statement that you're quoting was referring to? Are they specifically dealing with a case where a state has a number of different territories?
Absolutely.
They are addressing that question, or you are deducing it from what they say?
I better take that
Article
actually
29 of the Vienna Convention does not appear to be addressing that question.
it has been interpreted to mean everything, and we have got
Which is your best reference?
Sinclair at
This is a prima facie rule, isn't it?
yes I said
And this predates. I mean, the international law developed the clause which looks at individual territories simply because the prima facie rule was often
yes
inconvenient, if not unrealistic.
inconvenient and unrealistic. Absolutely, my lord. Absolutely. So you had the default provision. Sorry, you had the colonial clause precisely because of this underlying proposition, this underlying default rule. I called it a default rule. Yes, and Professor Malcolm Shaw, actually I don't need to take you to Sinclair because we've actually quoted Professor Shaw in the footnote. Practice would appear to suggest that in the absence of evidence to the contrary, a treaty would under customary law apply to the territory of a party, including colonies. Ignore the reference to Phyllis.
Sorry, which footnote is that, please? 92.
63.
No, it's 63.
63.
And it's tab 90.
Oh, tab, sorry. Yes.
Tab 92, which is volume 7. I'll give you the reference if you'd like to Shaw. It's volume 7, tab 92, page 5434. And then we've given you Anthony Oust as well, second and third line. Territory thus comprises the Metropolitan Territory and any other territory under its sovereignty, which I hope answers my Lord Sumption's point. And the reference for that is volume 7, tab 70, page 5180. So that's Oust. If you want the others, I can just...
Sorry, I've just been looking at 5434. Did you want us to look at that?
Sure, yes, my Lord, I'm very happy for you to look at that.
Well, no, it's what you were looking at. I mean, if you want me to look at something else, I'll look at something else.
What I was giving you...
What I asked you for was your best reference for the point you've been trying to make. And it's usually a good idea to start from your best reference, because if you don't succeed with that, you won't succeed in anything else.
Well, can we then look at Sinclair, which is at volume 7, tab 93, at page 5451.
Which bundle was it again?
7. Can you give me the bundle and tab number again?
793.
793.
Yep.
5451 to 5455. I've lost my note. I'm giving you the wrong reference. The correct page is 5440.
Sorry, 54,
40
40.
through to 50, the following page, 5441.
Application to territory.
Yes. And if you go to 5442.
When was this written?
1984, I think your footnote says.
You'll see that there's a reference sorry, it's McNair. I'm so sorry about this. If you go back to 5441, McNair expresses the predominant trend of opinion when he states the treaty may have such a kind it contains no obvious restriction. In such a case, the rule is subject to express or implied provision. To the contrary, the treaty applies to all the territory of the contracting party, whether metropolitan or not. And then the contrary view of several jurists. And then at 89, the practice of the UK tends in the direction indicated by McNair. And then a reference to the ILC, the Commission, matters stood before the Vienna Convention, and at the bottom of the page, the Commission stated that they preferred the phrase, the entire territory of each party, to the phrase, all the territory or territories for which the parties are internationally responsible because of the association of the latter term. The phrase, the entire territory of each party, was intended to be a comprehensive term designed to embrace all the land, abutment, territorial waters and airspace which constitute the territory of the state. So that was simply a less objectionable phrase for the phrase, all the territories for which the parties are internationally responsible. That's Sinclair. Perhaps it wasn't the best one.
I mean, the problem here is we've got a treaty which enables the state to extend it to a particular territory. So you start from the proposition it doesn't apply.
But the problem I have for my arguments, my Lord Sumption, my Lord Matts were putting to me, that my starting proposition is incorrect, namely that the UK acts differently depending on the circumstances. Our submission is, no, the default position is the UK acts as the state that is responsible for all of its territories, unless you have a contrary intention. We absolutely accept that the colonial clause establishes the contrary intention. We absolutely accept
I mean, there we are, yeah.
but I need the default proposition to explain why, when my Lord Mance puts to me that you need to have people conducting international relations, I can say it's the state that's conducting it, the state, the primary actor.
We ought to notice one qualification, oughtn't we? I mean, it may not be relevant in this case, but it's just important to notice this because some of these works are quite old. With the development of self-governing territories, I question whether your default proposition is of general application because, and you haven't got KO in the bundles, but we discussed this in KO.
We do have KO, actually.
Do you have it somewhere?
We do. The self-governing territories do have international legal personality, but it is limited to self-determination and sacred trust, Article 73. It's limited to that. And then they may have it in other contexts where there is something called entrustment, where the state, which is the primary actor, says to the overseas territory, well, you as my delegate can contract a treaty, and if other states agree, then the overseas territory can do it, but there it really is doing it on behalf of the state. That's a proper agency relationship, because the principal has power to act in the way that the agent has done. My learned friend's position is the reverse of what is the true position. So other than in entrustment contexts, other than for the purposes of self-determination, the overseas territory has no international legal personality. That is why you can have no permanent population in the South Sandwich Islands, and yet it can be a party to the ECHR. It is why you can have a fight about Rockall, because land generates international law rights and international law duties. And states can conduct international relations in respect of that land. It happens with great respect all the time, in respect of the Arctic search and rescue, tracts of Antarctica, remote islands, Patagonian fishing rights. Happens all the time, with very great respect. The people that my Lord was talking about are in the state. And obviously, one can have a situation, you can have a treaty where the land is the territory for which the state is responsible internationally and to which it extends a treaty. I'm now going to follow my case, if I may, from paragraph 81 onwards, at page 200, where we say that the concept of international responsibility for geographic territory is absolutely at the heart of international law, because the concept of state sovereignty itself is defined by reference to control over geographic territory. Could I just please invite you to read Professor Vaughan Lowe's extract that we've got there? If you want the original, I'll just give you the reference. Please don't, unless you want to take it up. It's volume 7, tab 86, page 5365. And the reference to Oppenheim in the next paragraph is volume 7, tab 83, 5329. The second proposition that we advance at paragraph 83 is that treaties have territorial application. It's central to treaty law that a state is responsible for the fulfillment of international obligations in respect of a certain geographic territory. And then the issue that we were looking at and we've quoted Villager. I think he was Mr. Villager was a judge of the European Court. The territory of a treaty, that's the original emphasis, the territory of a treaty covers the area over which a party to the treaty exercises sovereignty and thus embraces all that state's land, territorial waters and airspace, whether or not these areas are part of the metropolitan territory. So I did a pretty appalling job of answering my Lord Carnworth's question. It's there in black and white. I'm so sorry.
That's your best one.
Yes. Well, there are not... Alf says the same thing. Shaw says the same thing. We've got people saying the same thing. We saw from Sinclair that the term entire territory was replaced, was substituted...
Yeah, but I'm not sure why you're going on about this, since you accept that we're dealing with a particular treaty which departs from the general principle.
Because the contrary position was being put to me.
Yes, but I mean, you made your point.
5 minutes ago.
Yes,
So there you are. So different intentions would have to be negotiated if the contrary position were to be arrived at. The third point that we make at paragraph 84 is that a state's territory is not necessarily fixed. As my Lord Mance observed yesterday, there is an international law principle. It's called variously the moving boundaries principle. So we describe at paragraphs 85 to 87 how a state can lose sovereignty through international law doctrines such as conquest, cession, annexation, or the creation of an independent state, and obligations trace the boundaries of the state in terms of, if there is an independent state as we had it, in terms of Article 40 or an extension clause, it would lapse for the simple reason that you would not, as the state, be internationally responsible for the territory. We extend to Cyprus. The Republic of Cyprus is established. We are not responsible for the international relations of the territory of the Republic of Cyprus. You have to have territory and international relations responsibility. The fourth point just before I move to the fourth point, my learned friend Mr. Fordham makes a point at paragraph 19 of his case. I'd like me to pause for a minute. Paragraph 19 of his case at page 311, where he supposes independence being declared on part of the metropolitan territory, say Cornwall, it wouldn't then be necessary to re-accede to the Refugee Convention with respect to Dover. Or consider if Scotland declared independence, but the Shetland Islands wished to remain in the Union and did so. Would you have to re-accede vis-à-vis the Shetlands? Or indeed vis-à-vis the UK? Was it ever suggested before June last year that Scottish independence might mean that the UK's membership of the EU had to be renegotiated? The fourth proposition that we make is that, this is paragraph 88, that a state can limit consent to be bound to part of its metropolitan territory. So say not Cornwall, or not an area within Cornwall, provided other state parties agree. And it could then extend it under the territorial extension clause. The extension then would not be to a political entity. Bude in Cornwall is not a political entity in any significant, meaningful sense, or a separate constitutional unit separate from the metropolitan territory. It would be an area that was part of the metropolitan territory. And that suggests very strongly that a territory can mean land. The fact that the UK is responsible not just for that part of Cornwall's international relations wouldn't mean it wasn't territory for the international relations of which it was responsible. Our case at paragraph 90, moving boundaries also applies to the situation where there's an extension to an overseas territory. And there, the changing boundaries will alter the extent of the extension. And everything else being equal, the state will continue to be responsible for the observance of the treaty in respect of which the territory hasn't been lost, unless the obligation is specific to the land that has been, the Belgian example of maintaining fortresses that we gave with the previous page. And then our very important point, the relevance or otherwise of internal law, Bonku, with great respect, does not address the fundamental international law principle that a state can't use its domestic law by changing the status of its overseas territories so as to free itself or have the effect of freeing itself of international obligations that would otherwise arise. It can't shuffle the pack, as we, with respect, put it. My learned friend accepts that it was no part of the reasoning of Lord Hoffman that this principle, but that is a problem for him rather than of assistance. And we list the principles in our paragraph 29. Good faith, first of all, Article 27, at the top of page 204, Article 27 of the VCLT, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. And then the Danzig case, which my Lord mentioned a moment ago, where Poland was trying to invoke the constitution of the Free City of Danzig in respect of the treatment of Polish nationals. That was a city that was governed by the High Commission of the League of Nations at the time. But the court said, we've quoted the passage, the quote, for good measure said, not only can the state not rely on the provision of another state's constitution, but it said it can't adduce as against another state its own constitution with a view to evading obligations incumbent upon it under international law or treaties in force. And then subparagraph 4, provisions of municipal law can't prevail over those of a treaty. Oppenheim, treaties are binding on contracting states, changes in government, even the form of government of one of the parties don't affect, as a rule, the binding force of the treaties. That plainly applies to the abolition or creation of a new overseas territory. And then, importantly, I mentioned these yesterday, Articles 3 and 32 of the ILC's articles on responsibility for internationally wrongful acts. And I'll just give you the references, if I may, to the passages that we've quoted. And
I mean, all this seems to be a very long way away from this case. Of course, it's the case that you can't avoid your international law obligations by reference to your internal law or even your constitution. Yes. But you can certainly abolish yourself, you can merge yourself in another country, and your international obligations may cease then. And that's the sort of area we're in here, where we're talking about a particular territory disappearing, and that's a completely different ballgame.
With respect, no, because what your Lordship put to me yesterday with Jerusalem example, what your Lordship just puts to me in the first part of his question is merging with another state. So that would be an action on an international law plane, the application of international law doctrine.
We're talking
Second,
about actions on the international plane in the present case. It's argued.
only with respect to the establishment of the Republic of Cyprus. That, of course, is an action on the international law plane. You don't, by domestic law, enact a state. However, the creation of,
It strikes me as slightly strange to suggest that international law wouldn't recognise something as having happened in 1960. The fact is you have a treaty which is presumably justiciable in certain contexts, under which there are obligations and there are also intentions. All that could have and would have in certain contexts international significance. That we ultimately come back to a basic question, which this doesn't seem to me to address at all, namely whether it's right to treat the SBAs as effectively the continuation for present purposes of the old colony of Cyprus, and that's the question.
Let us say that there was legislation in 1960 saying the sovereign base areas are established as a new and separate colony, totally different from,
Yes.
as a matter of domestic constitutional law, the colony of Cyprus. That would be irrelevant in international law because they would still be part of the sovereign territory of the UK, and they would be territory, they would comprise territory in respect of which a treaty had been extended. There would be territory, in respect of which you have international relations. I'm sorry, my lord.
Do you say that the British Indian Ocean territory, that its creation was not something that international law can have regard to?
It can have regard to it as a fact, but it's of no relevance for present purposes at all. Because...
I understand your submission.
And there are, when we come to state practice, there are lots of examples of moving boundaries operating both with regard to the metropolitan territory. In fact, McNair cites with approval the British view with regard to an Anglo-French treaty that was agreed 4 years before France annexed Algeria, and the British view was, the treaty extended to Algeria, moving boundaries. I'll come to that in a minute, sorry. So we, with respect, say that this is absolutely, with great respect, my lord, on point, because what I was about to give you references to are propositions that internal law not only cannot be relied upon as a defence to non-performance, but it also cannot be relied upon to ground the proposition that the obligation doesn't exist. 32, what Professor Crawford, I think he was special rapporteur, it's not his commentary, it's the ILC's commentary, makes it, for whatever that's worth, it's both very eminent sources. But Professor, the commentary makes it clear that it's Article 32 that speaks to the performance rule. It's Article 3 which speaks to the anterior issue. And we've set it out. We say that the characterization of an act of state as internationally unlawful is governed by international law. Such characterization isn't affected by the characterization of the same act as lawful by internal law. That is absolutely, with great respect, on point. And they say this principle addresses the underlying question of the origin of responsibility. The reference, I'll just give it to you, I don't want to take you to it because of time. It's volume 6, tab 62, page 4873. And then also, Article 32, state may not rely on the provisions of its internal law as a justification for failure to comply with its obligations. That's the analogue of Article 27 of the VCLT. And then, but for good measure, what they say in their commentary is that international law does not recognise that the obligations of a responsible state are subject to the state's internal legal system. The UK's obligations under the Refugee Convention with respect to territory to which it extended the convention, i.e. Cyprus, are not subject to the UK's internal legal system in circumstances where it retains sovereignty over territory to which the extension has been made and in respect of which it is responsible for international relations. And the reference to that is it's the same tab, volume 6, tab 62, page 4929. And at subparagraph 7 on that page, 205, we make the point that a political entity, new or not, is not an actor in international law. The concept can't be invoked to avoid an international law obligation. If I can just jump forward a couple of pages, we give the example at paragraph 95 of our printed case of a maritime treaty between the UK and France, which expressly applies to the Channel Islands. We change our constitutional arrangements with respect to the islands. That wouldn't relieve us of treaty obligations to France. A change in respect of which France would not have consented, and he may not even know of. And there is an importance attached to visibility, certainty, accessibility, a fortiori, whereas here, the subject matter of the treaty is a matter of transnational concern. Refugee responsibility sharing is a matter of transnational concern. Article 46 of the Refugee Convention requires the depository, the Secretary General, to notify all other contracting states, indeed all members of the UN, of extensions that have been made. And that's the lex specialis of a general rule in the VCLT, Article 77, where the depository has that general function. And all treaties are, my lady will know, are required to be deposited in the UN depository under the Charter. That's Article 102 of the Charter. So there is a premium on visibility and legal certainty, transparency. And that it does not lend itself to the proposition that you can just rearrange your domestic constitutional units with the effect that you no longer have obligations. The Secretary of State, just leaving our case for a moment, the Secretary of State, as I said, agrees with this principle at paragraph 29 of her case, page 149, electronic. But she says that domestic law may be adduced as a fact to tend to show that the colony of Cyprus ceased to exist. We say, of course, internal laws can be adduced as facts. In the example that she gives, this is the German interest in Upper Silesia, it was internal laws which were inconsistent with international law and therefore established the breach of international law. Simply put, the issue was whether an act expropriating property by the Polish authorities in respect of German nationals meant that Poland was in breach of international law. That says nothing about the issue in our case. The Secretary of State says at paragraph 30, having said that this principle was no part of Bon Coup, says the key issue is whether the territory does exist, but she seeks to answer that question by reference to domestic law principles, and that violates this important principle. Can I just return to my case then? Our seventh proposition.
Can I ask you?
Sorry.
I'm really just returning to Lord Carnwath's point that if you look at Article 40 of the Refugee Convention,
Yes.
I appreciate your argument as a matter of generality, but we are here concerned with a specific treaty. in Article 40, paragraph 3 imposes a duty on the signatory state to consider the possibility of taking the necessary steps to extend the application of the convention to such territories, subject, when necessary, to the consent of the governments of such territories.
Yes.
Now, just say that you had a situation, for example, here, where you have an extension to the colony of Cyprus with the agreement of the government of Cyprus, and subsequently a large part of that colony becomes an independent country, and you're left with a rump, which, under the constitution given to it, has its own government.
Yes.
Well, in that situation, might it not be necessary for constitutional reasons for the United Kingdom to obtain the consent of the government of the rump in order to extend the treaties to it?
We accept that as a matter, or it certainly appears from the papers, that as a matter of internal law, there is a constitutional convention that the UK will consult.
Oh.
The important point, though, is that neither Article 40, subparagraph 1 or 2 are made contingent on the acquisition of consent in the travel. I'll come on to this in a moment, but Mr. Eady very tellingly said yesterday that the purpose of this clause, and he said from the UK's point of view, was all about consultation. And it's very interesting. If you just make one point, if you look at her secretary's case, paragraph 12, no need to turn up. At paragraph 12, page 143, what she says is that some of the considerations were concerned with obtaining consent. And then the next paragraph, she says, the purpose. If you just have that in your mind, one paragraph says some of the considerations were obtaining consent. The next paragraph says the purpose. With great respect, it is not the purpose. For example, in the travel, I'll come on to them in a moment, the US was saying, we don't do this. We don't consult with our overseas territories. Poland was saying that, look, this colonial clause is a device used by colonial powers to escape responsibilities and duties that are incumbent upon them. So yes, it was a consideration, but it is not dependent. 41 and 2 aren't dependent on consent. They're certainly not dependent on continued consent. There is the denunciation power if consent is withheld. And you've already seen the rule in Oppenheim, basic rule, that changes in government do not affect international responsibility.
So, I mean, obviously on your approach, in the situation that I was positing, the treaty would continue to apply to the rump because it had applied all along to that area of those areas of territory. And there would be no scope for seeking the consent of the new government established under the new constitution of the rump. But you would say that, well, that's not really what Article 40, paragraph 3 is meant to cover, and if there was a concern there, you would denounce the treaty and start all over again. Exactly. I see. Okay.
Exactly. I was on my seventh proposition, paragraph 92, the case, the denunciation clause, as it happens. That is also in the protocol, and the I'll just give you the reference. I'm afraid I'm one for big type, so the reference I've got is volume 1, tab 5, page 31, 1972. And we make the point that cushioning, the 1-year cushioning, it is perfectly understandable in the context of a treaty such as this, as regards other states in the region, as regards the UNHCR with its supervisory responsibilities, and not least with regard to the individuals who are in the state, or the overseas territory in respect of which the state is denouncing, so that they have time to absorb the change of position. And then, may I turn to state practice? I'll take this relatively quickly, if I may, again by reference to our printed case. So we give the first example at page 208 of Jamaica, Turks and Caicos, and Cayman. So this is a case of formal separation of Turks and Caicos and Cayman and constitutional change. In fact, it was the same extension as ours, as Cyprus. Just for your note, if you want it, it's core volume 3, 1B, tab 26, 939. And you have the UK saying, an internal memorandum, Commonwealth Office to the FCO, saying that the Refugee Convention applies to the Turks and Caicos and Cayman, quote unquote, as a result of extension of the convention to Jamaica. And the reference to that is 2A, tab 58, 1248. And then the next example at 101 is Rhodesia and Nyasaland. Here you have a dissolution, and multilateral treaties continue to apply. Reference in the passage quoted is Authorities 2, Authorities 2, tab 20, 3550. Paragraph 102, we have new constitution, governing arrangements, new name.
Did you have a page reference? You've just given...
Yeah, for 102.
402.
Sorry, in respect of 102, do you mean?
Well, you just gave us lots of references within the bundles, but you didn't give us a page reference, as I recall.
3550.
I thought I did. 3550.
2550.
No. Sorry, I'll start again. For 101, the page reference is Authorities Volume 2, tab 20, page 3550. Sorry, my lord.
Yep.
And then the next reference for paragraph 102, new constitution, governing arrangements, new name, status unchanged, UK remains responsible for external relations, treaties continue to extend, and that is the next page. So it's volume 2, tab 20, page 3551. And then 105, Netherlands, example of a very diverse way of structuring your overseas territories. Just to break it down, I hope this helps you. The Kingdom of Netherlands was the European territory plus the Dutch Antilles, all 6 of the islands that are mentioned. In 1986, Aruba secedes as an autonomous country within the Kingdom of Netherlands. So you have the European territory, the Dutch Antilles, and Aruba. Authorities, Volume 2, tab 19, a note from the Dutch in 1985, just before it secedes, to say that the treaties applying to the Dutch Antilles continue to apply to Aruba, despite the fact that it's seceded. 2010, the Dutch Antilles ceased to exist. And then the Kingdom of Netherlands is now Netherlands, which comprises Netherlands, the metropolitan territory, comprises the European territory plus 3 Caribbean islands. That's Bonaire, Saba, and St. Eustatius, plus 3 others. And then you have, in the same reference I gave you, despite the modification of structure, the Kingdom of the Netherlands saying we will remain subject to international law. So very different way of structuring overseas territories, lots of changes in internal constitutional arrangements, international obligations continue to apply. French Algiers, the reference I gave you, there's an error at line 3 at page 108 of our text. It shouldn't be 1926, it's 1826. So the treaty is 1826. It prevented restrictions being placed on British vessels. Question was, does it apply when ships arrive in Algiers? Algiers had been conquered in 1830. So here we have moving boundaries and the entire territory principle, the entire anti-shuffling point again. And the reference to McNair is volume 7, tab 88, pages 5391 to 2, 5391 to 2. Australia is another example, and the reference to Australia is again in the McNair article. It's volume 7, tab 88, and it's pages 5401. And then, do we have the Quark? I just hand up a one-pager on Quark, given that. Sorry.
I'm not sure the British government's argument in relation to Algiers looks completely convincing. Well, it may be, but I mean, if you have a treaty relating to trade, it might well be thought with France. It might well be thought that meant France, full stop. The idea that it necessarily applies if France incorporates Algeria or South Africa or India is, to my mind, slightly questionable.
It's moving boundaries.
Well, I know it is, but the British government argument seems to actually look at the reverse situation, limiting boundaries. Still, these are just arguments raised at the international level.
Indeed. So Quark.
Yes.
So wildlife inhabited land.
Thank you.
And what you have is an extension of the ECHR to the Falkland Islands on ratification. No fresh extension when the South Georgia, South Sandwich Islands become a separate overseas territory from the Falklands in 1985. The original extension to the Falklands is sufficient for the continued application of the ECHR after 1985. And we set out the chronology there. The issue is, there's a slightly complicated issue about time-limited extensions of the right of individual petition. But the underlying point that the ECHR extended by reference to an earlier extension to the Falkland Islands when South Georgia, South Sandwich Islands formed part of it, it's plain. And then the MLA treaties. Sorry, there's the annexation first of Cyprus, page 100, paragraph 110 of our case. So Cyprus is annexed in 1914. You'll remember, and McNair refers to that at volume 7, tab 88, page 5394. Then the MLA treaties. Which, would you like references to all of those treaties?
Why don't you just send them in,
I'll do that.
rather than spend time on your feet?
Thank you,
with
my
those
lady.
page
I'm
references?
very grateful. Married women, I will take you to, if I may. And we have that at volume 2, tab 23. At page 3582. So here you have a 1957 UN Convention, nationality of married women. And if you see at the bottom of the page, you see an extension to Cyprus, 4 lines down. Also, the next line, Jamaica, just for good measure. And then when we look at denunciation, that's the extension, sorry, the notification of extension. Then the denunciation, which we have at 3594, at 3594, we see denunciation in respect of the United Kingdom's sovereign-based areas of Akrotiri and Delikia in the island of Cyprus. If you make a mental note of the name used there, it's conspicuous that the sovereign-based areas are inconsistently referred to. It's as if they don't really have a settled name. Schedule 6 to the 2002 Act refers to them by reference to the area. It says, this is the listing of overseas territories, and it says, I'll give you the reference in a moment. It says sovereign-based areas, that is to say, the area. And you have inconsistent referencing. Sometimes they're called Cyprus, sovereign-based areas. Sometimes they're called sovereign-based areas in Cyprus. If you're creating a new constitutional unit, this goes to argument 1, the least you would expect is a settled name. And also, just in the denunciation, the previous page, you'll see Cayman Islands are also there. There's a denunciation. And just above the sovereign-based areas, the Turks and Caicos. Mr. Eady mentioned the ECHR, extension to the sovereign-based areas in 2004. We say that is belt and braces, it's emphatic. The consequence of my learned friend being correct is that there would be an awful lot of unravelling to do with respect to the state practice that we've identified. The consequence of my argument being correct would simply be that this was an emphatic extension. And then...
When you say this, that's, sorry, what are we actually referring to there?
ECHR.
It's ECHR.
Where's the extension?
We were referred to it yesterday, 2004.
Right, I see. You can't give us the reference. No, I've got it somewhere then.
You will have it. Yeah.
Then, my lords, running over time, I'm going to deal as quickly as I can with 3 points, and this is context. It touches on the point that my Lord Reid put to me, the on behalf of issue, and then difficulties. So those 3 points, central themes in my learned friend's case. My learned friend says the context of Article 40 drives the Secretary of State to say that territory doesn't mean land, as it can in Article 29. She accepts that in her reply at paragraph 26. She accepts that in Article 29 it can mean land. And we say, well, Article 40 establishes the contrary intention. So it would be odd if it also, at least potentially, didn't mean land. The context is given by the use of the word territory in the Refugee Convention. It's very clear that territory means land in almost all the articles when it appears. You look at 33, no refugee shall be referred to the frontiers of a territory where his or her life or freedom, etc. Article 31, the criminal immunity provision. persons entering the territory. Refugees lawfully present in the territory. When you've got reference to political entity, it's either country or state in the Refugee Convention. So that's also the context. Then you've got the basic principle that the Refugee Convention is to be construed broadly. I've already made the point that in answer to my Lord Reed's question about how 40 and 41 are not contingent on consent. There are territorial application clauses. I found one in reading Professor Simpson's book on opium production, which is absolutely contingent on obtaining consent. This isn't one. There's no single reason for a clause such as Article 40. The travaux, I'll just give you the reference, the travaux cited by my learned friend at volume 6, tab 59, page 4796. The travaux cited, in fact, refer to the International Covenant on Civil and Political Rights. You'll see the references in the travaux to the covenant. What happened was that the drafters obtained a report in respect of discussions concerning the covenant because they wanted to see what the views were, but it's actually in respect of another instrument where there was no territorial application clause. I made the point about the USA, the reference, the USA saying, we don't consult. That's volume 6, tab 59, page 4798. The reference to Poland saying, look, this is a device that you use to escape responsibilities. That's at volume 6, page 59, tab 59, page 4802. Sir James Fawcett saying sometimes these clauses are inserted in order so that the state can protect itself. The reference is volume 7, tab 73, page 5158. And the overall point is that there were a very wide variety of overseas territories held by different states in different ways. Some could be no more than land masses, some could be effectively part of the metropolitan territory. For some purposes, see the Netherlands. The clause is intended to have wide application to all of them. That's the context. Agency on behalf of. Can I just ask you to just turn up quark fishing? So quark fishing is at volume 9, tab 106. And my learned friend Mr. Fordham cites Lord Nichols. It's page 5853. Yep. My learned friend Mr. Hickman reminds me that the premise of the consideration here was that the ECHR was applying. And then Lord Bingham says at paragraph 3, page 5862, Paragraph 3, that if you just look at just below letter B, SGSSI is a legal entity, but the United Kingdom is responsible for its external relations and thus has the responsibility in international law for ensuring compliance with those international obligations which apply to it. And that we say, Lord Bingham, if I may say so with ever, very carefully using his words, that is the correct way of looking at it. It is the UK's obligation. My Lord, and Lord Manson and I had an exchange yesterday about what's the difference between on behalf of, in respect of. I think the difference is who has the obligation. In domestic law, it may very well be that the overseas territory has the obligation vis-à-vis the metropolitan state. That's the gist of Fawcett's article. It's the territory's obligation. My learned friend seeks to erect his whole case on that proposition. The on behalf of does a lot of work for him in issue 1. It does a lot of work for him in issue 2. It, with respect, can't do any work because as a matter of international law, it is the UK's obligation to ensure compliance.
I think Mr. Eady does make that absolutely clear in paragraph 15 of his case.
No, but he says it doesn't matter. It's an afterthought for him. His analysis isn't altered by the fact that the UK is responsible. We say that's not just an afterthought.
Well, the consequences of responsibility are obviously something else, but that the contracting state is responsible and we shouldn't be too much confused by reference to on behalf of,
yes.
He makes that absolutely clear.
But he's saying in substance, the obligation is that of the overseas territory, because he says that what the state is doing, the metropolitan state is doing, is acting through a diplomatic channel that is not available to the overseas territory. It's almost a conduit, to use the phrase that my lords, my ladies. But that's his analysis. In substance, it is the obligation of the overseas territory. That's why the unit of analysis is always the overseas territory. You've got to assimilate in the overseas territory. You can't move other than out of the overseas territory. It's limited to the overseas territory. Why is that? Because it's the overseas territory's obligation. The overseas territory has said, yes, we will sign up. And the UK is just a facilitator. That's all it is. And then yes, it is true that he says at the end of a couple of paragraphs in his case, this analysis isn't affected by the fact that UK is ultimately responsible. Well, with respect, the obligation is that of the UK.
Yes.
That's our basic point. Lord
Yes.
Nicholl says the same thing my learned friend quotes him, paragraph 36, page 58.
Speaking for myself, I wouldn't labour this point anymore.
Sorry, thank you. I'll just give you a reference to Oppenheim on entrustment, volume 7, tab 83, pages 5313 to 4. And then 2 references to Fawcett, which are quite illuminating, really. Right? He says at volume 7, tab 73, page 5147, he says this: there is indeed a close similarity between some of the rules of Commonwealth constitutional law and those of international law, but it would be incorrect to identify them. It's the first thing he says. And the second thing he says at page 5159 is that the colonial application clause, when it is included in multilateral treaties, is of course designed to meet the constitutional requirements of all states having such territories, but it would be impossible within present limits to discuss the position in these cases. Fawcett, it really isn't on point here. We have a multilateral treaty. His thesis is basically a thesis of British constitutional law. We respectfully submit. And then difficulties, my learned friend's reference to the difficulties. Well, denunciation is the obvious answer with the protection that it gives you. The UK has an absolute legal right to denounce. Nobody could do anything about it. It may be politically difficult, but legally it could not. No one could do the faintest thing about it. Insofar as the idea is that it's impossible or difficult to perform the obligations, as the Court of Appeal said, there is no impossibility whatsoever in the contracting state, that is to say the UK, performing its obligations. There is a concept in international law of supervening impossibility of performance in Article 61 of the VCLT. That is not pleaded. No one's ever heard any argument about it. It's an extraordinarily high test. Economic resources are not an answer. And it is a logically different issue from the prior question of whether the treaty remains extended. And you have the lex specialis of denunciation. And just to close on this, my Lord Wilson yesterday saying, this theme is rather difficult to reconcile with the policy commitment to fully respect my client's refugee rights, except on the most austere view of spirit. So that's argument 3. I've gone over time. In terms of the practice direction, the 1966 practice direction, we noted a couple of cases, but Horton and Sadler, Lord Bingham saying that, of course, you don't lightly depart. However, where too rigid adherence to precedent might lead to injustice and unduly restrict the development of the law, the House will depart where it appears right to do so. That's Horton v. Sadler, 2007, 1 appeal cases, 307, paragraph 29. 2007, 1 appeal cases, 307, paragraph 29. Those observations apply here, we'd respectfully submit. And you obviously have the point that whatever else it could be said about my submissions, it wouldn't be said that the issue was only lightly touched upon. Too heavily touched upon. And then, my lords, I'm going to jump back, my lady, I'm going to jump back and do this very quickly to issue 1 and make good my framework point that assume that I'm wrong about all of that. What is a new political entity? How do you judge it? We say you look at the legal situation, the legal classification. You don't look behind the constitutional status of the land. Let me just have a moment, sorry. My friend saying that you look at all the circumstances, we say that's wrong. As a matter of domestic constitutional law, new colonies are created by orders in council or primary legislation. On the Belmarsh facts, there was a new overseas territory. What did I say? Belmarsh, sorry, Bonku, I mean, of course. And then, again, references which apply in this context as they did in under argument 3, paragraphs 57 and 58 of our case. Can I just ask you to look at those in our printed case? Page 191. So this is Oppenheim and O'Connell. Changes in government, form of government, don't affect the binding force. O'Connell, changes of government, there's an error there, shouldn't be responsibility, should be personality. Changes of government does not affect, change of government don't affect the personality of a state, etc. The references are Oppenheim 7, volume 7, tab 83, page 5321, and O'Connell, volume 7, tab 90, page 5420. So my learned friends' repeated reliance on the social, political, geographic, legal changes really just doesn't bite at all, with great respect to him. There is no change in the status of the constitutional units. If my learned friends is right, then you are inviting an impressionistic analysis which is antithetical to the context in which this concept is being used, i.e. international relations, where there is a premium on visibility and transparency for all the reasons I gave. And we make the point at paragraph 60 to 64 about how the history of BOTs is often one of upheaval, reorganization, and constitutional change, giving examples of Turks and Caicos. It would be intolerable, we say, if a state would have to examine the nature and extent of such changes to see whether the UK continues to owe obligations in respect of an overseas territory, such as the Turks and Caicos. 8 changes of constitution in about 20 years, constitutional change being a triennial activity, as Louis Blom-Kluper's commission.
Again, it seems to me you're beating in the air, aren't you, on this point, because nobody is suggesting that a mere change of an internal constitutional nature is the end of the matter.
Well, I think Mr. Reedy is suggesting.
I think he says you've got to look at it also in an international context. There was.
May I rhetorically ask, what is his test? What's his test? It's an elephant test. If it looks like a new entity, it is a new entity. That's what it is. There's nowhere in his written case, his reply, his oral submissions, has he given you a test. Fairly significant, given the context is one of international relations and other states knowing where they stand. And given the history, we say that is, with great respect, untenable. There is a jury point, if I may say so, in the Secretary of State's case at paragraph 3, where they say, well, here you are saying you've got to look at domestic law. You say you can't look at domestic law because of Article 27 of the VCLT. We said, of course, our primary argument is that you can't, for the reasons I just gave you at great length, over length. But on this aspect of the case, you have to, you're driven to look at national law. And then the argument, I'm just going to give you the references in our case. It's paragraphs 34 to 54, pages 185 to 190, for why we say they're not a new entity. First, they're, as a matter of domestic law, they are BOTs. They are still in substance a colony. Insofar as it's interesting, they were a colony too in 1960. The Interpretation Act of 1889, Section 18.3, which was in operation in 1960, is I'll just give you the references where it's set out, if you're interested in it. Volume 6 of the Authorities Bundle, tab 65, 5053, and also Fawcett 773, page 5186. They were a colony by that definition. They remained the same colony because of the legislative position, the description. Contrast the Antarctic Territory Order, Article 3, which you have at Volume 1, Tab 7, page 3246. Biot, give me 1 second, I'm so sorry. We say some confirmatory support. Sorry, the Antarctic Territory Order.
It's volume 2. You said volume 1.
Did I? I'm sorry. It's
That's
volume
okay.
2. But it's paragraph 39 of our case. If you just look at that, please. Form a separate colony.
Yes.
And then over the page,
That's simply because they were being split off from the Falklands, Antarctic.
But so, but the point is that is how the legislation describes them. So it's new. And we have some confirmatory support from an ordinance of 16th August. We've set out at paragraph 43, where, as regards residents, in paragraph 18.3, it's stated, in deciding whether or not the name of a person shall be included in the recognised residence list, the administration will consider only whether the normal place of residence of such persons immediately before the appointed day was situated in a part of the colony comprised in the areas after that day. And you'll see the reference to where we have that. At Core Volume 3, 1B, tab 32, 1052. In fact, if you look at 1042, you will see that that ordinance is current at 2010. So 7 years ago, that is the provision of Article 18.3, situated in a part of the colony comprised in the areas after that day.
So you're saying it's now that suggests that we now should refer to the sovereign base areas as a colony?
They technically are, yes, of course they are.
Surely what it means is in a territorial, a bit of territory which was part of the colonies, which
yes.
bit of territory is now comprised in the areas after that day?
Yes, and that suggests it's the rump. But are they colonies as a matter of... I absolutely take the point about their sui generis nature, I do, but as a matter of statutory interpretation, they absolutely are colonies. If you look at our case, page 37, the definition is set out there. Paragraph 37, sorry.
Paragraph?
37, page 185. Yes, they are a colony with great respect.
Does it matter? I suppose you want to make that point because previously there was reference to the colony of Cyprus, yes. And you're saying that most of Cyprus having sailed away, the sovereign base areas remain a colony. I suppose you're saying that, but they remain within British sovereignty. Whether you call them a colony or a territory, does it matter? Your argument?
Just as a matter of statutory definition, they're not something different. So I suppose it does. I mean, Mr. Rees is going to say they're just something that's sui generis, as in answer to your question, my lady president, then we would say, well, yes, I can see why he says that, but as a matter of constitutional law, they are absolutely a colony because of the Interpretation Act.
I think my lady's point is that the essential underpinning of your case is that the United Kingdom maintains sovereignty over the sovereign base areas.
Yes, that's it.
And nomenclature is therefore a secondary consideration, whether it's described as a colony or something else.
That's our primary case. But on this part, I can see if the statute was referring to these, if there was a statute provision which say the sovereign base areas shall be constituted a sui generis overseas territory subject to rule by the military of defence as almost as if they were part of the non-contiguous metropolitan state, I can see why I'd have difficult argument on this part of my case. But it doesn't say that at all. It just doesn't say anything about the establishment. The Act, the orders say nothing about the establishment of the sovereign base areas. And if you look at the statutory definition, they remain a colony and they are a British overseas territory. That's perhaps less germane to the issue. And then you have the point in Finnis, my Lord Carnworth noted, at paragraph 45. And also the distinction between Biot, its creation as a new colony, its description as a new separate colony, and our case was recognised by the Court of Appeal at paragraph 57, and that's at page, Core Volume 2, tab 3, page 354, as did the dissentient judge, Mr. Justice Collender, in the local court, Core Volume 3, 1B, tab 20, 801 to 2, paragraph 61. Rump part, he said. But Finnis is at page 188, and here we say he's absolutely right. Biot was page 188 of our core volume, paragraph 45, Halsbury's laws. Biot was created a separate colony, paragraph 46. In contrast, sovereign base areas consist of those portions of the colony of Cyprus that weren't established as the Republic of Cyprus and remain within sovereignty and jurisdiction. They are to be regarded, therefore, as constituting a colony acquired by conquest, the First World War, or cession, the treaty, the Lausanne Treaty, as from the 5th of November 1914, when they were annexed unilaterally. Sorry, you've got the Court of Appeal and Mr. Justice Collins set out on the next page. And then we make some points about the Appendix O. It's simply a declaration. Colonies appears in quotation marks. That's all I'm going to say about argument 1. And then argument 2, that there's sufficient continuity anyway, even if you look at all the circumstances. I'm just going to ask you, please, just to take my case as it appears on paper from paragraphs 65 to 71, pages 193 to 197. I'll just make 5 points, if I may. Firstly, the representative element was the Legislative Council. The powers of this council were always limited and advisory. Second point, it was abolished in 1931. As we explain with great respect at paragraph 1215 of our case.
Sorry, 121.
121, subparagraph 5, and that's at page 217. Fawcett was wrong in his rough categorization of Cyprus. Didn't have a legislative element. Legislative Council had been abolished 18 years previously. Fourth point, the fact that there were village councils in 6 towns had municipal corporations isn't relevant in this context. And the last point, there was sufficient continuity in governing arrangements. See our Annex B, which shows that the changes were mainly nomenclature. Governor became administrator, laws became ordinances, and so forth, and that's set out at page 291 and following. That's all I want to say, if I may, about our second argument. I now then want to move on to issue 2, a little bit later than I'd wanted. May I please have a 2-minute break?
Of course you may. I think rather, shall we rise just for a moment and you let us know when you're ready?
Thank you very much.
Issue 2.
Thank you very much, my lady. I'm very sorry for the inconvenience caused.
Don't worry, no, it was quite convenient for us too.
So issues 2 and 5, we address these at our case, pages 220 to 249, paragraphs 128 to 201. My learned friend, Mr. Fordham, in his case, at paragraphs 5 to 9, paragraph 13, and then 27 to 31, pages 305 to 7 and 314 to 15. My learned friend, Mr. Eady, pages 151 to 160, 34 to 62. Now, there are 6 steps to the conclusion that the Secretary of State must exercise her power to grant entry. And I need to take this slightly slowly because it appears that Mr. Eady was, with great respect to him, hitting at a straw man yesterday. The first step is the Secretary of State accepting correctly that her decisions must be consistent with the Refugee Convention. Lord Reed's point. Our paragraph 11 of our printed case, page 179, section 2 of the 93 Act, nothing in the immigration rules shall lay down any practice which would be contrary to the Convention. A fortiori immigration policies.
Sorry, what was the reference again?
To our paragraph.
Just give me the references. Paragraph.
Paragraph 11, page 179.
Thank you.
Primacy of the Convention. Nothing in the immigration rules shall lay down any practice which would be contrary to the Convention. A fortiori immigration policies and decisions. Rules have legislative imprimatur. See Roma Rights, volume 4, tab 37. Lord Bingham at paragraph 7. Lord Steyn at paragraph 41. So the immigration rules are a sideshow here. Reference in the decision of July 2017 is a sideshow. Immigration rules, whilst very important, usually as an indication of how the Secretary of State structures her discretion, her statutory discretion, are irrelevant here because the Refugee Convention trumps. And that's accepted. Second step, there is a protracted, present, and potentially indefinite breach of the respondent's rights under the Refugee Convention in the sovereign base areas. Now, we were told yesterday this isn't common ground. It certainly was below. Even if it's not, our submission will be, it's not open for Mr. Eady to challenge it because there were clear findings in the courts below, in Ms. Justice Foskett. He didn't appeal them, Secretary of State didn't appeal them. That's it. It doesn't matter whether it's common ground or not.
Sorry, can you give me what the clear finding paragraph in Mr. Justice Foskett?
3972. I'll develop it in a moment, if I may. He says that you cannot have your rights delivered under the Refugee Convention in the sovereign base areas. That was
a slightly different point. I understand that, yes.
So there is a protracted, present, potentially indefinite breach of your rights as refugees in the sovereign base areas. This is, I'll come on to.
No, I mean, it doesn't help to assert that it's common ground when it clearly isn't. But so one needs to know what it is you're saying. And I understand you're saying that it's clear that they can't meet the rights under the convention within the sovereign area.
I'll show you.
Yes, I understand that.
I'll show you 3 places where in his pleadings, which were authored by Mr.
The question for us is whether they can achieve it by their arrangements with the Republic of Cyprus. You say they can't. I mean, that's what we're doing.
Well, can I just take it in stages, because it is, with respect,
You
important.
need to, but
You'll see why I thought it was common ground. You'll see that in a moment. The third step is that there is no other British overseas territory to which the Refugee Convention has been extended and in which the UK could discharge its obligations towards them identified. In 19 years, there has not been another overseas territory identified where refugee rights could be delivered. I think that's just uncontroversial. The fourth step, also uncontroversial, I hope, is that the Secretary of State has power to grant entry to the UK where the UK can discharge those obligations. Or Lord Bingham in Quark, ensure compliance. The UK can ensure compliance. The fifth step is that the Secretary of State's solution that the respondents should, regardless of consent, relocate to the Republic is unlawful. It is.
I don't think that suggestion is being made.
It absolutely has, my lord. That's the first suggestion. If you look at the letter, for example, of if you look at the letter technically under challenge, the proposition is you can go to Cyprus. The secondary submission is you can stay in the sovereign base areas. Query, my lord, Lord Wilson, where? You can stay there and have your rights delivered to you through the agency of the Republic. I'll come on to that in a moment. I'll certainly address it. I need to address it, of course I do. But that is being said.
that is the case. I mean, I don't know why we go around all these 7 propositions. What he's saying is, yes, we can't meet your rights within the territory itself, but we have arrangements which are as good. Now, either that's a good proposition or it's a bad proposition. But there's no doubt what he's saying, as I understand it, and really we've got to decide whether that's right or wrong.
I'm trying to explain what the consequence is of that.
I understand. We understand all this, as they're set out in enormous detail in your case. But we've really got to focus on this major issue, which is a very worrying and difficult one.
We are not seeking declaratory relief that the Secretary of State's options are unlawful. I'm trying to explain why the consequence of our submissions, if we are right, mean that the Secretary of State has to exercise the power that she has.
Yeah, you say the only way that she can do what she has to do is by bringing them to this country. Well, we understand that. The question is whether the options that he is putting forward do the trick, and you say they don't. Well, that's what we're on about, and it's just very frustrating. We never seem to get to that point.
I will certainly address you on it in a moment. The sixth step was going to be...
Let's have your sixth proposition. And then...
Sorry.
The sixth point was going to be that the alternative solution, that the respondents should stay in the SBAs and rely on the Republic for delivery of their rights, is also unlawful because step 2, convention obligations cannot be discharged whilst they're in the SBA. The where question, where are they going to go? The obligations can't be exported to a third state, as the Court of Appeal said. For example, naturalization and assimilation. And a fortiori, where the MOU is not fit for purpose, as we say, it is not. And I was going to say, if you want a headline for the fifth step, the reason we say the fifth step is unlawful, relocate to the Republic, is because it is premised on an illegality, namely Article 32, which says that you can't expel a refugee lawfully on your territory, save on grounds of national security or public order. And the respondents are neither of these. That step confuses the respondent status as refugees lawfully in the territory with asylum seekers. You tell them to go to a safe third country, and also refugees who are national security or public order risks. They don't have the benefit of this protection. And I'll develop, we put it in two ways you'll have seen in the case. A, you can't premise that. You can't premise your solution on something that's not permitted. And secondly, the more extreme version of the case, which we say we have a run at, we don't need it at all, the constructive expulsion. It's not right to say that nobody's gone, my lord. One of the respondents did, Shermas. And so we say the conclusion of those 6 steps is that the Secretary has to exercise her power to grant entry in order to avert the breaches, in order to avoid the UK remaining in continuing breach of the Refugee Convention. So the right of entry that is claimed is consequential. It's consequential on the UK's continuing breach in the SBAs and on an inability to transfer to another overseas territory where the refugee rights could be delivered, and on the illegality of her solutions.
So what should the Secretary of State be doing to ensure that there are no breaches in the SBAs? I mean, the premise of your argument is that because there are breaches in the SBAs, therefore they must come, she must admit them to the UK. But that postulates that there's something that should be happening in the SBAs, which is not being offered or not happening. What is it?
Satisfaction of refugee rights.
No, but
Which ones?
Well, I suppose you mean proper housing,
Yes.
proper welfare benefits, proper opportunities to work, proper education.
Yes. How about not having asbestos in your house?
All right, okay, that's what I want to answer to. You say that she's got to change the housing. As for right to work, that wouldn't be, I think, permitted under the international arrangement with the Republic of Cyprus.
Yes,
would
and
it?
that's a problem. That's a problem for the UK.
I mean, what you're saying is that
It's exactly the point.
in fact, it's impossible to satisfy, so all refugees who arrive in the bases must come here.
No, because the asylum seekers who arrive, they can be moved elsewhere to a safe third country. The only protection they have is against non-refoulement.
Now, let's talk about people accepted refugees.
Yes, people accepted as refugees, if they're not national security risks, they have to have their rights respected.
And so, I mean, the consequence of this is, that, on your argument, it's impossible to satisfy the Refugee Convention.
It is.
In respect to the SBAs.
And
and therefore, the only way of satisfying is that they must come here.
It's what Mr. Eadie said 3 times in his pleadings below. 3 times he said that. Summary grounds once, detailed grounds twice.
So this does apply to any refugees who arrive in the SBAs?
Not who arrive, but who are recognised and who are lawfully in. Yes, it does. And this is why it's so important that it is recognised that the obligation is that of the UK. Mr. Eadie needs to say it's the obligation of the sovereign base areas, because then he can say, well, go to the local court, like Mr. Hessu did, missing out the point that Mr. Hessu was a failed asylum seeker. I'll give you the reference. He didn't have any rights on the Refugee Convention, assuming it applies. We're now assuming it applies. And we can't go to the local court and say, well, it's impossible to deliver the rights. Therefore, tell the administrator to move us to somewhere else where we can, that's part of the contracting state's territory. Yeah, I mean, there is a basic distinction between people who arrive to claim asylum and people who are recognised as refugees. It's absolutely central to our case. We'll see in a moment that resettlement programmes, Professor Hathaway says the window of opportunity is short, the temporal window of opportunity. Because once you are recognised as a refugee lawfully in the territory, you cannot be expelled against your will unless you are a national security or public order threat. Now, that of itself doesn't get us here. Of course it doesn't. It's the paragraph I pointed to. Housing, no asbestos, please. Education, employment, public welfare, healthcare.
Well, let's look at those. Housing, the Secretary of State it is possible to build housing for them that doesn't have asbestos.
£500,000.
Education, the Secretary of State can arrange for, and indeed has arranged, because your clients are taking advantage of it, for them to be educated in the Republic of Cyprus. Employment, Article 17 entitles them to be accorded the most favourable treatment accorded to nationals of a foreign country in the same circumstances. What's the comparator?
The comparator there would be Syrian, Iraqi, Sudanese and Eritrean nationals. But the more interesting article...
What, in the SPAs?
Wouldn't it be the Cypriots who are living in the SPAs?
And the Cypriots. And
Aren't they an obvious example?
Sorry, I'm being stupid. You're absolutely right, my lady. The more interesting examples, my lord, are the articles, such as public relief, Article 23, which the comparator is your own nationals. There are own nationals on the SBAs. They have access to very considerable recreation health facilities, and they are UK civilian personnel.
Well,
that's your comparator.
If we're looking at employment,
yes,
you're saying that we have the obligation to employ them on the sovereign base area.
No, you have the obligation to guarantee equal treatment with foreign nationals. But
I mean, the Cypriots.
Can we just take housing? Sorry, my lord.
The Cypriots their status is that they don't have any guarantee of employment within the sovereign base areas. If there's a job for them, they can have it. Most of them, as I understand the evidence, in fact, are employed, although they reside in the sovereign base areas, they are actually employed elsewhere in the Republic of Cyprus. Now, what is the position of your clients as regards employment in the Republic of Cyprus? They might have to sign on, which they don't want to do, but it's available, isn't it?
In the Republic, yes, but the criterion there is most favourable treatment that any foreign national is afforded so I was wrong to say equal treatment, it's the most favourable treatment, and if there are Cypriots who are working on the military bases or as part of the fire service, the police service, the infrastructure, then they have equivalent rights to that.
Are you saying they've got to be offered a job, or that they've got to have a legal status which permits them to accept such job as may be available for them?
The latter. They have to have access to this.
It's the same treatment, isn't it, Article 24?
24, did you say?
I thought we were talking about labour legislation and social security.
My lord was looking at Article 17.
Looking at Article 17.
No, sorry. I'm sorry about that. Thanks.
But when you look at public welfare, which is fairly significant in their circumstances.
You're quite right, for most favourable treatment.
Sorry?
Yeah, sorry, no, I apologise. Most favourable treatment, yeah,
not
Article 17. Yeah.
But if you look at public relief, then the standard in Article 23, and this doesn't disappear as a right because it's inconvenient. You have that at Volume 1, Tab 53147. Contracting states shall accord to refugees lawfully staying in their territory the same treatment with respect to public relief and assistance as is accorded to their own nationals. Now, it may be inconvenient that there are UK nationals on the bases with access to perfectly fine, high level of recreational activities and so forth, healthcare, education. The references for that are Mr. Justice Foskett, paragraph 57, page 308, C to D, where he cites from my instructing solicitor, Miss Gregory's statement, and then just a couple of other paragraphs, 55 at page 379. So there's a comparator there. Is that right being satisfied? No, it's not. My lord put housing to me. Yes, the UK could arrange for housing to be built at a cost of £500,000, but it has been ruled out. I'll show you the minute from Mr. Gondel where he proposes that. But for 19 years, my clients have been living in the accommodation that you've seen. Asbestos was discovered 9 years ago. They are living in housing as asbestos. That is why Mr. Justice Foskett said that there was an urgency in this case. That will inform the this, with respect, completely unacceptable idea of remittal. Make submissions on that in a moment. But there is a very long-standing, flagrant, continuing breach of these rights. Can I say something about these rights? My learned friend said that, as I understood him, that there weren't, the Refugee Convention wasn't about rights, or that the rights were weak because the comparator was to align with aliens. Well, some of the rights do. Your lordship showed me one of them, others don't. So that's one point. You have a higher standard. But there's a far, far deeper point. And this is it. In 1960, as far as Europe is concerned, in 1963, the European Commission started developing a refoulement, non-refoulement component to Article 3 of the ECHR. So you can't expel to Article 3 ill treatment. You then had the Torture Convention in 1984, which built on the Commission jurisprudence. You then had Chahal in 1996, which in terms said Article 3 goes further than Article 33 of the Refugee Convention because Article 3 ECHR is absolute. Mr. Chahal, you all know, a very, very famous case, was a threat to national security. Article 3 is absolute. Article 33 of the Refugee Convention isn't. So therefore, Article 33, non-refoulement, is not particularly significant in the European legal space. So why is refugee status important? It's important because of everything else. The articles we've been looking at in the convention, you look at its title. It's a convention relating to the status of refugees. That gives you a clue. The drafters, the states, privileged a class of aliens 3 years after the Universal Declaration, gave them very, very extensive rights. In that era, absolutely unique. The status rights, Mr. Fordham mentions them at his paragraph 5, right to access court, public relief, housing, education, labour market, self-employment, administrative assistance for all of that. And which other protection instruments gives you a surrogate passport? Article 28. And gives it for aliens. You are supposed more than to just tolerate them. You're supposed to, as a contracting state, to restore dignity. Mr. Fordham cites the RT Zimbabwe case, but many of my ladies, my lords, will restore that, will recall that. In that case, also the HJ Iran case, this court said the fundamental purpose of the Refugee Convention is to permit refugees to live openly and freely in accordance with their protected characteristics under the Refugee Convention. And he suggests, my learned friend, that you can add to that dignity. We respectfully concur. The preamble says at volume 1, tab 5, page 3136, it refers to the profound concern to assure refugees the widest possible exercise of fundamental rights and freedoms. This is why I opened with Lord Justice Steyn, as he then was. These are not empty words, and they might be thought to be incompatible with living amongst asbestos for some 9 years. Our courts have recognised this basic protective, restorative purpose. See our case at paragraph 209, page 251. Leading scholars, one of the world's leading scholars, if not the world leading scholar, Professor Hathaway, has said, we quote him at paragraph 208, page 251, that the function of refugee rights are the means by which the international community has agreed to restore to refugees the basic ability to function within a new national community. The rights set by the Convention are the core minimum judged necessary to compensate refugees for the situation-specific disabilities to which involuntary migration has subjected them. They need...
Can I just go back on one point, just so my note is correct? At one point a moment ago, you were saying that the correct comparator was British nationals working for the purposes of which articles?
Article 23, which is the public relief article.
Yes.
Well, it varies from article to article.
It does.
I just wanted to get which were the ones you were particularly relying on in the present context.
Education, Article 22. Those two. Public relief is obviously very wide.
But education is, yes, I see.
22.
Yes, fine. Yep.
Own nationals.
Yeah.
But it's, Article 23 is a very significant one because it's of wide scope. For obvious reasons, public relief.
The elementary education, it is, yeah.
Sorry, yeah, you're absolutely right. You're absolutely right.
Yep.
No doubt you'll come to it, but as I read the Court of Appeal judgment,
Yes.
while they accepted that current conditions were not acceptable, the ground on which they considered that that the refugees could not be, that it was impossible for the refugees to be treated compatibly with the Convention while residing in the SBAs, was because of the impossibility of assimilation and naturalization in accordance with Article 34.
You're absolutely. I was going to come to Article 34. They picked that one out.
And they say, and the impossibility arose, as I understood it, from it being in conflict with the obligations which the UK had undertaken in the treaty with the Republic of Cyprus.
My Lord,
So you're going to come on to that.
I will come on to that, but your Lordship is absolutely right, because you've got to have a society to assimilate into. You've got to facilitate that. There isn't a duty to actually achieve it. It's a process duty, but certainly if you do nothing, it's a breach of it. That's what Professor Hathaway says. And absolutely, that was the thing that the Court of Appeal alighted on, the article that they alighted upon. And they said it certainly isn't possible for the UK to discharge that obligation because you bring them here.
Well, the population of the SBAs consists, apart from the transient population of military and ancillary civil personnel from the UK, it consists of 10,000 Cypriots. That is the society into which they fall to be assimilated or naturalised, is it not?
Well, if I can interject, I mean, I think what the Court of Appeal were focusing on was a prohibition on allowing non-Cypriots to settle in the SBAs, other than military personnel and their families.
Yes, my lord's absolutely right, but also the very design of the Refugee Convention is that it allocates rights according to graduated and increasing levels of attachment. So you get some rights when you're subject to the jurisdiction. You're coming here and you're intercepted on the high seas and you're sent back to persecution. The House of Lords and Roma Rights said that that is a breach of Article 33. They overruled a US Supreme Court case which said the opposite. So that's the first tier. You subject somebody to your jurisdiction. Then there's a second tier of rights which attach to refugees who are in your territory. Then there is a third category of refugees who are lawfully present. Then there's a category of those lawfully staying. And then there's a category of those lawfully resident. And then if you get nationality, that terminates your refugee status. So the very design of the Refugee Convention is incompatible with Appendix O.
Yeah, I imagine you're going to come on to this, but Mr. Eady, on the other hand, was relying on the Memorandum of Understanding as indicating that, in fact, there was a readiness on the part of the Republic to accept the presence of refugees in the SBAs.
The memorandum...
I'm not trying to take you out of your order. I just wonder, given the Court of Appeal's approach and the fact that we're not a fact-finding court, whether there's a great deal of mileage for you in arguing about asbestos and so forth, if the ground of the decision in your favour was a legal impossibility.
Well, there's an absolute finding, a clear finding which is not subject to appeal, that there is asbestos in the housing, which happens to be the cause of urgency.
Yes,
that's just
but that's a problem capable of being overcome given the will to spend the money.
9 years, my lord?
Well, yes.
At what point, I mean, Mr. Fordham says enough is enough. I mean, how long does this go on for, with great respect? But I take your point. That's a clear legal point. Can I answer it this way? The MOU may permit these refugees by way of exception to Appendix O to stay, but because of its presence, you don't have a society there. Hence, you can't assimilate into anything. There are other problems with it, which is that it involves a transfer of responsibility. What you certainly cannot do on the Refugee Convention is say to the refugee, you're another state's responsibility. You absolutely can't do that. It's absolutely contrary to Article 13, contrary to, almost to good faith. You could do it with respect to asylum seekers. You can send them to safe third countries. But you can't do it. My lords, I need to develop some preliminary points. And the first one of those is, what does territory mean? And we address this at paragraphs 131 to 132 of our printed case, pages 222 to 3. And we say, sorry, if I just have a moment, I'm so sorry. So what does territory mean? We say, for reasons which I sought to persuade my lords of, my lady of earlier, in particular in answer to my lords, Lord Sumption and Lord Nance, that territory means both the metropolitan territory and the overseas territory to which the extension has been made. Now, the contrary proposition is understandably central to my learned friend's case. He says it only means the overseas territory. That helps him to a colossal degree because we are then left with moving the local court and asking the secretary and asking the administrator to breach Appendix O, create a society, spend £500,000 on accommodation, not move us to a detention camp. The Hesu case, paragraph 91, by the way, the alternative accommodation offered was found to be akin to a detention camp in the view of the judge. So it's central to my learned friend to say territory means the small unit, nothing else. We say, with great respect, that's absolutely wrong. You have to situate Article 40 and the term territory in the controlling rule of international law. It's not just the relevant rule of international law under the Vienna Convention. I'm referring to 31.1c. If you please look at 1311, this is the controlling rule. It's a default rule that territory includes metropolitan and overseas. And we've given you, I can give you the reference, it's footnote 63, page 201. That's the footnote where I spectacularly failed in answering my Lord Carnot, giving him the best point when it was staring me in the face. So that is the default rule. That is displaced by Article 40, establishes a contrary intention. But once you extend, then the default rule is engaged, again, to that extent. And that is why the Refugee Convention uses the term territory in the singular, because it is used in the singular in Article 29 of the VCLT. There is no basis for suggesting that somehow the metropolitan territory disappears. Under the Vienna Convention, Article 29, the only room for debate is whether entire territory means your metropolitan and overseas. No one's ever suggested that it might mean just your overseas, unless, of course, you are simply an agent, a conduit of the overseas territory, which has zero international legal personality in this context. Unless there's entrustment, there isn't. Unless you're talking about self-determination of peoples, which you're not. So how on earth does the metropolitan territory suddenly disappear from the context of territory? It's an extraordinary proposition, with great respect. If you needed textual support, you have that in Article 19.2, highly skilled refugees. Article 19.2 says, with respect to those, states shall use their best endeavours to secure the settlement of such refugees in the territories other than the metropolitan territories for whose international relations they're responsible. That is the only time that phrase appears in the body of the articles of the Convention, the substantive content of the Convention. It's the only time it appears. What does that tell us? It tells us that when the drafters wanted to limit the scope of an obligation to non-metropolitan territories, they did it in very clear terms. If you don't have that express limiting language, the obvious meaning is that territory includes both metropolitan and overseas, in respect of which the extension has been given. There is no doubt, but were there to be any doubt, you would employ a broad interpretation for the reason I gave earlier. The preambular purpose of the Refugee Convention is to assure to refugees the widest possible exercise of their fundamental freedoms. That is not secured by saying to them, you can be third-class refugees living, I'm sorry to say this again, in asbestos.
Yeah, can we just go back,
Yes.
just look at Article 26.
Yes.
Each contracting state shall accord to refugees lawfully in its territory the right to choose their place of residence to move freely within its territory, subject to any regulations applicable to
Yes.
aliens generally in the same circumstances. So that if you had restrictions in respect of aliens,
Yes.
then you could apply them also to a refugee. that's within the territory, but supposing you have a set up, as you have with the British Overseas Territories, where actually the locals can't move to another British Overseas Territory or to the Metropolitan Territory.
Yes.
Are you suggesting that this article puts accepted refugees in a better position
Not at
than
all.
the locals?
Not at all. And this is really important because it absolutely demonstrates that Mr. Eadie's caricature of my case is exactly that. Article 26 says the opposite. It prevents the refugee roaming across the world in every British overseas territory, including the Metropolitan Territory,
Now, why?
unless...
How come? What's the language?
Because unless aliens generally in the same circumstances have that right. If they have that right, then the refugee does. But if they don't, as they don't in British overseas territories, then nor does the refugee. It's a straw man, again.
Can we just pause at that moment?
Yes.
It seems quite an appropriate point at which to pause. I imagine you've got more to say about that in due course. We'll look forward to hearing from you again.
Thank you, my
at
lady.
2:00. We'll now adjourn.